Anthony and Caroline Bergman from Pinsent Masons. We are very glad that we are able to have you here to take us through this, these amendments and the impact on businesses and what seems to be particularly from a compliance point of view. Mel has just put something in the chat just to ask everybody if you could put your name and designation and company, because we don't have necessarily all the attendees on our database, because some of the emails were forwarded to HR or elsewhere in the business. And on that happy note, I'm going to say welcome to all of you. Thank you for joining us. We will be sending the recording out, and I'm going to hand over to Anthony. Thank you very much. Anthony, can I just ask, would you prefer questions at the end, or is it fine for people to ask during?
I think it's better at the end.
Okay.
The subject matter is quite dry.
Okay.
I'm actually pretty easy. If we can possibly
Okay.
just say it at the end, might be easier.
All right. So I think if anybody's got particular questions, you can pop them in the chat, or when Anthony's finished, we'll do a Q&A. So over to you, Anthony and Caroline. Thank you very much.
Thanks, Gillian. Should we move on to the first slide? Okay, so today we're going to talk about the amendments to the Companies Act. The recent amendments to the South African Companies Act were signed into law by President Ramaphosa on the 26th of July, 2024. They were introduced to address several critical issues within the business sector. The aim of the amendment is to enhance corporate governance, transparency, and efficiency, making the conduct of businesses less burdensome. They also focus on tightening the pursuit of delinquent directors for wrongdoing, including state capture, and addressing disparities in earnings. By implementing these changes, the government seeks, obviously, to create a more robust and fair business environment in South Africa, I think in the hope of attracting foreign investment. Good morning. My name is Anthony Crane. I'm a partner in the transactional services team at Pinsent Masons in Johannesburg. With me is Caroline Bergman, an associate in the transactional team. We specialize in commercial law, and obviously today we're going to talk to you about these recent amendments. As Gillian mentioned, it's an important piece of legislation for all businesses operating in South Africa. And as you'll see from what we have to say, it will have a major impact on your business going forward. Next slide. Sorry, I can't control the slide, so I have to ask Caroline to. So turning to the First Amendment, which occurs at Section 16 of the Companies Act, a deeming provision has been introduced to promote certainty as to when an amendment to the company MOI takes effect. As you all probably know, the MOI is the governing document of a company. It is binding on directors, shareholders, and prescribed officers of a company. It supersedes all other documents, including the shareholders agreement. And when you incorporate a company usually has a standard MOI, but this is often changed to suit the needs of the members, and an amended MOI is thereafter lodged with SIPC, the company's office. So the question that always arises in practice is, when does the amended MOI actually take effect? Currently, there are two views on this. In practice, the view of many legal practitioners is that the amended MOI takes effect on the date on which the notice of amendment is lodged with SIPC. But unfortunately, SIPC themselves take a contrary view, and they say that the amendment only takes effect once they inform you that the amendment has been accepted. This is usually done by way of an email notice and can take anything from 24 hours to 3 weeks. It really just depends, and often creates a lot of uncertainty. So the amendment to Section 16 now addresses this problem by providing that an amended MOI will be deemed to take effect on the 10th business day after the lodging of the notice of amendment, unless, of course, it's approved earlier by SIPC or rejected. And one of the other interesting parts of the amendment is that it's now also possible to state in the notice of amendment itself the date on which the amended MOI is to take effect, which is also sort of fairly useful and provides certainty to parties. So this amendment, unlike some of the others that we will discuss, actually solves a practical issue and is a welcome development. I'll now ask Caroline to take you through the next couple of amendments, and then I'll jump back in. Thanks. Next slide, I suppose.
Great, thanks, Ant. All right, so before I jump into more of the amendments, I just want to go through this concept of a public interest score, because this becomes important later on, because certain amendments only apply to companies with a certain public interest score. So, for example, some amendments apply...
Your camera on.
Sorry?
Your camera, it's not on.
Can you guys see me or not?
No, I don't, well, I can't, so I don't know.
No, it just says Caroline Bergman.
Okay, let me put my camera
Sorry, just a
on.
technical issue. I didn't pick that up at the beginning.
There we go.
Let's see if you come online.
Now we can see.
Great, perfect.
Thank you.
All right, I'll pull the slides back up. Okay, so jumping back into the public interest score. So as I was saying, the public interest score of a company becomes important in the context of these amendments, because certain amendments only apply to companies with a certain public interest score. For example, if you've got a public interest score of above 100 or above 350, certain things do or do not apply. So basically, a public interest score is used to determine three things. Firstly, whether a company's annual financial statements have to be independently audited. Two, what the financial reporting standards are that apply to the company. And three, whether the company is required to have a social and ethics committee. And we'll touch on social and ethics committees a bit later. Then the next question that we usually get is, okay, how do we then calculate a public interest score? So it's quite a simple calculation. It's based on four main factors, and it's supposed to be calculated annually. So the first factor is the number of employees of your company. So each employee counts as 1 point. The next factor is the company's turnover. So for every 1 million rand or part thereof of annual turnover, you get an additional point towards your public interest score. The third factor is third-party liabilities. So every 1 million rand or part thereof of liabilities that's owed to third parties counts as an additional 1 point. And then lastly, each shareholder of the company counts as 1 point. We have summarized, just for your benefits, this table of the implications of what your company's public interest score is in relation to filing requirements of annual returns, audit requirements, access to company information, and whether or not a social and ethics committee is required. All right, now going into the next amendment. So the next amendment deals with the location of company records. So this is a very small amendment, but it's important to keep this in mind when we go through some of the amendments that follow. So in short, a company has always had the obligation to inform SIPC where its records are kept. But following this amendment, SIPC is now actually going to be required to publish where the company keeps its records. So once the changes take effect, SIPC will have to publish the location of the company records, and anyone can then go and do a search on SIPC to see where those records are kept. This is important information for anyone that might be seeking to get a hold of those company records. So before I go into the next amendment, which deals with access to company records, I just want to give you guys some background. So currently under Section 24 of the Act, every company is obliged to maintain certain records. This includes its MOI, its record of directors, its securities register, and so on. As further background, you should also know that Section 26(1) of the Companies Act grants members of the company with the right to access certain records of the company at no cost. And when I speak about members, I'm just talking about shareholders and other beneficial interest holders, so shareholders of a shareholder. So essentially, if you are a shareholder of a company, you can simply request certain records from the company, and the company is obliged to give it to you at no cost. In addition, Section 26(2) allows any person, any non-member, and I mean this includes any member of the public, with the right to access certain records of the company. And they do this by coming to the company and paying the prescribed fee, which is currently set at 100 Rand. And after that, the company is required to provide those records to the third party within 14 business days. That's the current position. So now going into the actual amendment to Section 26. So these are important because it expands the list of company records that must be made available to shareholders and the public. So currently, shareholders, you'll see on this side I've got member, shareholders, members, they're entitled to request copies of the MOI, the record of directors, the reports to annual meetings, the annual financial statements, notices and minutes of annual meetings, and the securities or share register of the company. The amendment just simply adds the beneficial interest register to the list of documents that can be requested by a shareholder or member of the company. And the reason that the beneficial interest register has been added to this list is because there was previously an amendment to the Act, I think in around April 2023, which sets out that a company is required to now create a beneficial interest register, and they need to file this with SIPC. And this register essentially goes upwards to show the shareholders of the company all the way up to the ultimate beneficial owner. So as you can see, it's not really a big change for the position of a member or a shareholder. All they get additional access to now is the beneficial interest register. However, for non-members or the general public, the amendment has a much larger impact. So as you can see from the slide, the current position is that non-members can only currently request a copy of the securities register of a company. As I said before, this is upon payment of the prescribed fee of 100 Rand. However, the amendment now seeks to allow non-members, members of the public, to request copies of a company's MOI, its record of directors, and in certain circumstances, the annual financial statements. I'll come back to this in a moment. In addition, they can still obviously obtain access to the securities register, the share register, but the beneficial interest register will also be added to this list. So going back to the financials, and this is where the public interest score that I was discussing earlier becomes relevant. So if you are a private company with a public interest score below a certain number, you do not need to provide your financials to the public. The idea is that a private company of a certain size, so rather larger private companies, need to make the same kind of disclosures as a public company. Because as we all know, public companies and listed companies need to have their financials listed on their website. So if you're now a large private company, you're going to be held to the same standard as public companies and listed companies. Where this becomes interesting, and I'm going to deal with this aspect shortly, is that there are certain new inclusions which are going to be required in companies' annual financial statements. And this information, this new information, is quite personal to directors, and it's got some directors quite upset. So just in summary on this amendment to Section 26, the impacts of the amendments are that the list of companies' records which are accessible by third parties has been quite significantly expanded. In addition, the period by which access needs to be granted has been reduced from 14 business days to 10 business days. So it's a shorter period for companies to actually provide those documents to third parties after they've paid their 100 Rand. Okay, now on to one of the more controversial amendments. So it's already controversial enough that public companies, and now, based on the previous amendment, large private companies are going to be required to make their financials available to the public. You worry about competitors seeing this information. It's quite a sensitive topic. So the problem is that Section 30 is now going to say that if you are a company that is required to have your annual financial statements audited, your financials are going to be required now to set out each director individually, as well as what they earn. This includes not only a director's remuneration, but also any kind of benefits received by the directors. And if you're a director of a larger company, your benefits could be substantially more than your pay, because maybe you get a housing benefit or a car, share incentive schemes, all sorts of other benefits like schooling benefits. It can be quite substantial. So the Act used to say that directors and individuals holding any prescribed office had to have their remuneration set out in the financials, but this could be one globular figure. You could have a one-line entry that just says director's remuneration X. Now, however, based on this amendment, the directors need to be individually named, and as I've said, their remuneration must be very clearly set out together with all of their benefits. So you'll see that this section also refers to prescribed officers, and the remuneration of prescribed officers needs to also be included in the financials. So the question that we often then get is, okay, well, what is a prescribed officer? And that's an excellent question because nobody really knows. The Act says that the minister was at some point supposed to promulgate a list of job roles that are going to be designated as prescribed officer roles. And the question that we see most regularly is whether or not a company secretary can be considered a prescribed officer. So the minister has never, in fact, promulgated this list of prescribed officers. So currently there's no list. So all we have to go on is the fact that the regulations say that a prescribed officer is anyone who exercises general executive control over and management of the whole or a significant portion of the business and the activities of the company, or a person who regularly participates to a material degree in the exercise of general executive control over and management of the whole or a significant portion of the business and the activities of the company. So ordinarily, a company secretary won't really fall into this role. The problem is whether anyone is now likely to be putting up their hand to say, yes, I am a prescribed officer, and please won't you put my remuneration and all my benefits in the financial statements, please. This is just not going to happen. So the minister is now, we anticipate, probably going to finally promulgate the list of prescribed officer roles so that we actually have certainty and clarity on who is considered a prescribed officer. Now, this has had quite an interesting effect. This whole amendment has had an interesting effect for directors and larger private companies, because now that remuneration needs to be set out in the financials. And also when you pair this with the fact that any person can go and run a search on Subsea on a company and obtain the personal or the addresses of directors, and sometimes this is their personal addresses, this has left quite a lot of directors feeling quite vulnerable.
Yeah, so I mean, basically just to reiterate what Caroline is saying, I mean, we've seen a lot of companies are concerned for the safety of their directors. And those of them who've actually considered the amendment and know that they will need to comply with this reporting requirement have actively been approaching us to sort of change the home addresses of their directors on Subsea to the business address of the company to try and sort of protect them a bit. We've also actually seen some directors choosing or certainly discussing resignation because they don't want resignation from their role, because they don't want their remuneration and information made public. We recently had one client who said she wanted to resign as a director for this reason, and we asked her what she intended her role in the company to be. She said her intention was obviously to keep her existing role, but without the formal title of director. The problem, however, which we pointed out to her, was that if she did this, she would probably still be regarded as a prescribed officer, and the remuneration would need to be disclosed anyway, so it wouldn't really solve the problem. But turning on to the next amendment, which occurs at section 33. Yeah, we've got the slider. So the next amendment occurs at section 33, which deals with annual returns. Unlike before, the amendment will require companies with a certain PI score that Caroline's already mentioned to include its annual financial statements when submitting the annual return. This becomes problematic. Well, where it becomes problematic is that if you file the annual financial statements with your annual return to subsidiary, it basically means that any member of the public can go directly to subsidiary and access that annual return and the annual financial statements, and then, by implication, access all of the remuneration information of the directors. So, I mean, we've thought about it, and if someone is looking for specific information, and they're actually quite smart, they could go straight to subsidiary as opposed to approaching the company and paying the R100 fee as a non-member to get hold of this kind of information. And the benefit to them of going directly to subsidiary instead of approaching the company is that they could actually remain completely anonymous, because subsidiary doesn't keep records of information requests, and they don't also advise, we don't know who they've released information to. So I think, as soon as this amendment comes into effect, I mean, just by way of example, a journalist, looking for a story could go to subsidiary, look up the remuneration of that director, and because they avoided approaching the company through the non-member channel, that director could be totally blindsided. Obviously, we've already mentioned the safety concerns as well. Another noteworthy change is the introduction of new provisions under sections 30A and 30B of the Act, which oblige, and this only applies to state-owned enterprises and public companies, to prepare and present for approval by the shareholders a remuneration policy and a remuneration report. The remuneration policy must be enforced for 3 years and reapproved sort of every 3 years thereafter. Can we go to the next slide? And the remuneration report must be presented every year following the approval of the remuneration policy, and importantly includes what's called an implementation report, which sets out the details of the highest and lowest paid employees in the company. Again, this only applies to SOEs and public companies, and the amendments have been introduced to promote greater transparency, which I suppose is a positive development, but it could also be open to abuse and by mischief-making individuals set on harming those companies. So we'll have to see how this all plays out.
All right. The next amendment is dealing with the validation of the irregular creation, allotment, or issuing of shares. So for those of you that have ever been involved in a situation where a company has issued shares incorrectly, you'll be very grateful for the insertion of this section. Now, the first question would be, how does a company issue shares irregularly? So, for example, and just going back to the example we used earlier and discussed about the amendment of the company's MOI, let's say you've submitted an amendment of the company's MOI to subsidiary, and the amendment to the MOI allows the company to issue a new class of shares, for example, or maybe preference shares. And then you go ahead and you issue the shares before the amendment has been effected. So you haven't heard back from subsidiary saying everything is in the clear, it's all good. Then subsidiary comes back with an issue and rejects the amendment for some reason, but you've now already gone and you've issued the shares. Well, this new section will assist in resolving situations like that. because the section allows the company to go to court and ask the court to validate or regularize the issue of those shares, because otherwise the company will be stuck in a situation where it's trying now to unscramble an egg. So it's a lot better to just be able to go to court. And just interestingly, the court will only grant the order where it is satisfied that it is just and equitable to do so. So it's interesting to see that we've got the concept of equity coming in here. So the next amendment deals with consideration for shares. So if you are involved in a transaction where the company is issuing shares today, but payment of the purchase price for those shares will only be received at a later date. So we're talking a situation where there's sweat equity is involved. The Act now allows the shares to be held in escrow until payment has been received. So the reason for this amendment is that this section was previously interpreted to mean that the shares needed to be held in a trust because of this reference to, you'll see on screen here, to a trust agreement. And I'm not sure if any of you have had to deal with the master's office recently, but if so, then you'll know that getting a trust set up is no easy feat. It's a long, cumbersome process, and it's really just not a fun time.
It's a mess.
So now this section has been changed so that it's clear that the shares can be held in terms of a stakeholder agreement. And this just means that, for example, now an attorney or an escrow agent or another third party can just hold on to those shares on behalf of the entity that will eventually be issued those shares. And this is quite a useful change that we think is going to be used quite a lot in practice going forward. I'm now going to hand over back to Anthony, who's going to take us through some changes dealing with financial assistance.
So yes, the next change is introduced to Section 45, and I guess is a welcome one. Section 45 deals with the obligations of a company when offering financial assistance, quote unquote, and the new provisions now say that if a company is providing financial assistance to a subsidiary, this will now be excluded from the definition of financial assistance. By creating this exception, it effectively means that a company will no longer be required to obtain shareholder approval, board approval, or apply the solvency and liquidity test before it can provide financial assistance to its subsidiary. And this obviously alleviates the burden of the company from having to go through this sort of painful and expensive process to comply with these Section 45 obligations. I think it is, however, important to note that the exception only applies to local subsidiaries, and the obligations under Section 45 will still apply to any company offering financial assistance to an offshore entity. So I think that's the change at Section 45. Let's move on to the next slide.
All right. This next amendment deals with share buybacks. So a share buyback, which is also known as like a share repurchase, is when a company buys back shares from its own shareholders. So Section 48 was a provision that used to give people quite a headache, because if you wanted to do a share buyback of more than 5% of the shares in the company, you needed to get a special resolution passed and an independent expert report needed to be prepared. And this was quite a time-consuming and expensive exercise, especially for smaller companies. The key change that's brought about by this amendment is the removal of the 5% threshold, because now under the new provisions, all share buybacks, regardless of size, are going to require shareholder approval through a special resolution, which is typically set at 75%. However, there are some exceptions to this requirement. So if the share buyback is being made as part of a pro rata offer to all shareholders of a particular class, or it's pursuant to a share buyback conducted on a recognized stock exchange, then you are not required to pass a special resolution. So this does provide some flexibility for companies in managing their share repurchase strategies. This slide just kind of sets out, just included for your benefit, the actual details of the amendment. So just to give you some context, where everything is in square brackets in black, that's what's been deleted, and everything that's in red and underlined is the new insertions.
That's me, right?
Mm-hmm.
Takes a bit of time. The amendment to Section 61 deals with how public companies conduct their shareholder meetings. In short, public companies are required to hold an annual general meeting of the shareholders. So once a year, all the shareholders come together and with the directors, who then present on the state of affairs of the company to those shareholders. We also then have an opportunity to question the directors or the board and to vote on certain matters. The amendment to Section 61 now requires directors, when presenting to the shareholders at the AGM, to include a section on the Social and Ethics Committee report, which Caroline will discuss shortly, and the remuneration report, which we mentioned earlier. In addition, the amendment provides shareholders with the opportunity to vote on the composition of the Social and Ethics Committee.
Okay, so now I'm going to speak about what the Social and Ethics Committee actually is. So Section 72 of the Act allows the Board of Directors to delegate certain functions to committees. And one of the committees that some companies generally have is the Social and Ethics Committee. So the SEC is a committee that is concerned with the company's responsibilities in areas dealing with social, commercial, and environmental matters. And it was formally introduced into South African law by the 2008 Companies Act. So firstly, it's important to remember that not all entities are required to have a Social and Ethics Committee. There are only 3 categories of companies which are required to have an SEC. These are all state-owned companies, public companies, and any company with a public interest score exceeding 500, and I think that 500 figure needs to have been in place for 2 years. However, companies are able to approach the tribunal to request an exemption from needing to form a Social and Ethics Committee. So previously, the Act did not specify how the Social and Ethics Committee should be composed. And this amendment now requires that the SEC must consist of at least 3 directors or prescribed officers. And importantly, at least one of these directors must be independent when it's a profit company forming the Social and Ethics Committee. Independent just means that these directors should not be involved in the day-to-day management of the company and must not have been involved in the past 3 financial years. But when you're dealing with a public or a state-owned company, then it's the majority of the directors that are on the SEC that need to be independent. So it's not just one. It's if there's 3, then at least 2. The SEC needs to be appointed annually by the board. This just ensures regular oversight and accountability. And additionally, any vacancies to the Social and Ethics Committee must be filled within 40 days. The amendment also requires that the Social and Ethics Committee report needs to be presented at the AGM, but alternatively, the report can also be approved by shareholders just through a written resolution.
So depending on your point of view or where you sit, there is a welcome amendment to Section 77 of the Act, which deals with the liability of directors and prescribed officers. This amendment stems from one of the recommendations of the Zondo Commission following the state capture inquiries. So Section 77 deals with the liability of directors for breach of their fiduciary duties. At the moment, the Act provides that directors are only liable for loss or damages caused by them for a period of 3 years from the act or omission giving rise to the liability. In other words, there's a 3-year prescription period. The amendment, however, now changes this by allowing an aggrieved party to request the court to extend this 3-year prescription period on good cause shown. So again, depending on your point of view, now may not be a good time to be a director of a company because it may not be open to you to argue that a matter has prescribed. It is also important to note that this change is retrospective, which is interesting, and it ties in with another change at section 162, which Caroline will discuss, and is, I suppose, thankfully, the last amendment that we discussed today. So just be warned about that one.
All right. So the final section, as Anthony said, that we'll be discussing is the amendment to section 162, and this deals with an application to declare a director delinquent or under probation. So the amendment to this section essentially just extends the time frame for declaring a director delinquent. So previously, you could only apply to declare a director delinquent if they had been a director within the last 24 months prior to the application. Now this period, based on this amendment, has been extended to 60 months. And in addition, parties are allowed to go to court to ask the court to extend that 60-month period on good cause shown. This means that if a director has engaged in misconduct, you now have a much longer period to hold them accountable and seek a declaration of delinquency. This change is also retrospective.
Final slide. So that concludes our presentation for today. I know there is a lot to take in, and we went through it fairly quickly. But these amendments, I suppose the important point is these amendments have not yet come into effect, which gives companies enough time to consider them and how they may impact their business. There's bound to be a lot of articles out there discussing these new provisions, and more will follow. So I'd urge you all to keep a lookout for these, and we'd be happy to take any questions now, and we'll do our best to answer them. But also, if not, you are welcome to reach out to us. I think finally, I'd just like to express my thanks to the ACA for arranging this opportunity. Gillian, Sharon, and Melanie, thank you very much.
Thanks very much, Anthony. The one thought I just had, and I'm not, as involved as some of the other people on the call who might want to have questions, was just around the privacy aspects of some of these. It's quite hectic what people are actually allowed to do, and there seems to be kind of a what happens to the various privacy protections that people have.
Yeah, so I mean, we haven't really considered the implications of POPIA and information that is ought to be disclosed in this act. But the Companies Act is one of the is one of the fundamental pieces of legislation in South Africa, and often trumps other legislation. So it may be that it trumps POPIA to a certain extent. We haven't quite got our heads around it. We're still doing so. And I think, again, I think the purpose of, I suppose, today is really just to alert everyone to this development. And as I said, we do have some companies are sort of changing their directors' home address to business addresses.
Interesting.
We've got I heard Justin Naylor from I2 on the radio the other day, and he was talking about the prevalence of he offers specialized risk insurance, and he was talking about the prevalence or the upticking trend of kidnapping in South Africa. If you think about it, I mean, you can basically, somebody could, if I'm a director of a large company, somebody could access those records, find out my home address, see what I earn.
See what you earn, like a shopping list, yeah.
So it is quite concerning, and but that's what the Act says at the moment, and we're just going to see how it plays out over time, I guess.
But we must just keep in mind that it's only applicable, those disclosures, for public companies and those larger private companies with higher public interest scores. So it's not going to be every company across the board.
Yeah, absolutely.
Yeah, great. Okay, any questions, anyone?
Good morning. My name is Nombini Mehlomakulu. I'm from Ebony and Ivory. Thank you very much. This has been most informative. Are we able to get a copy of this so that we can set up follow-up meetings?
Yeah, I think that's fine. We'll make a copy available to the ACA, to Gillian and her team, and then they can distribute. But I've made a note here.
Thank you very much, Anthony.
Sure.
It's really informative. Some of these are, and yeah, thank you.
Okay, great. Pleasure.
I think the key is the threshold and us understanding where we fall on the threshold of the disclosure.
Yeah, I mean, we if you consider the one or two of the slides in the deck actually do sort of out the threshold. So, but I mean, also you're welcome to reach out and we can assist there.
Thank you.
Cool.
Graham Vivian has his hand up.
Oh, I can't see that. Graham, I thought you'd have a question, Graham.
Hi, Anthony. Just a question with regards to disclosure of directors, where it talks about you have to do it if you're required to have an audit. Is that if you're required to have an audit per the Companies Act or per your MOI?
So if you're required to have well, your MOI can stipulate obviously whether the company must be audited or not. But I think it talks mainly to if you are required under the Companies Act to have an audit based on your public interest score. Caroline, I don't know, do you have any thoughts on that?
Yeah, if I could just go back to the slide that actually deals with it. You see, we've set it out. So the audit requirement under the Companies Act deals with these relevant public interest scores. So in certain circumstances, companies with a public interest score of 100 to 349, only if their financials have been prepared internally, then they're required to be independently reviewed. Now, there's a bit of debate whether that independent review means audit or not, but I think it is correct to say that if it's only based on the company's MOI that your financials need to be audited, that then wouldn't apply, that those disclosures wouldn't apply, because the intention of the Act or legislature seems to be that only larger companies, larger private companies need to make the same sort of disclosures that private companies, or public companies and listed companies need to make. So I think that's the key.
Yeah, it's the public interest score that seems to be the determining factor.
Okay, thank you, because that will make quite a big difference. I think for a lot of, I think there's lots of companies who are required to do an audit for their MOI, but I think if you look at most of our members, I think a large portion of them will not be more than 350. And getting your financials independently audited, prepared is not that difficult. So I think for most of our members, they need to, be able to avoid having to do this. So, yeah.
Yeah, I mean, I don't think the intention of the amendment is to now force a whole lot of companies to change their MOI so that they just produce financials without the audit. Audits are obviously, that provision is there for the protection of shareholders mainly. So yeah, I don't think the intention is to try and work around it by now, sort of getting rid of that requirement if you have that requirement under the MOI, although it could be useful to argue that.
And sorry, just to add to that for everybody, the reason why this is even more important is that for most of us, whenever we're submitting tenders, a whole bunch of people require us to submit our financial statements. And what this would mean is that it's not just that your financial statements might be available, you'll be sending these financial statements through to who knows who and where those sit. So it's definitely a huge risk for everyone to be aware of. You can potentially redact your financial statements, but yeah, it's something for you to consider because that's where it becomes public quite quickly.
Yeah, especially if they're lodged, as we said, with SIPC, then it's easy to access.
What just be clear, what happens is we send this to some procurement person in a company who in theory should keep it confidential, but frankly, by the time it's hit that company, you have no idea where it's gone to. So it's even less secure than going to SIPC. So yeah.
Sure.
Any other questions? Any other hands up? Can't see. Thanks so much, Anthony and Caroline. I think it's been really interesting and food for thought. We'll share the deck and the recording. And if anyone wants to reach out directly to you for additional questions, they're obviously welcome to do that. So thank you.
Thank you.
Thank you, everyone.
Thanks. Thanks for organizing. Bye, everyone.
Thank you.